Okay, I see everybody here. Mr. Donovan, you're the appellant. Do you want to reserve 5 minutes?
Yes, sir. 5 minutes for rebuttal.
Okay, 5 it is. We're ready whenever you are.
Thank you. May it please the court. I am here on behalf of the appellant Mark Pulte as personal representative of the estate of William Pulte. The trial court should not have enforced the settlement agreement because the trial court lacked enforcement jurisdiction and because the trial court lacked personal jurisdiction over the trust and because the estate's fraudulent inducement defense was not time barred by Florida Rule of Civil Procedure 1.540B. I'll take these points in the same order that I just rose them, as well as address them in the brief. So the probate court lacked jurisdiction here to enforce a settlement agreement because as the Supreme Court created a very bright line rule resolving multiple conflicts in 2003 in its Palucci decision, stating very clearly when a trial court continues to have jurisdiction to enforce a settlement agreement. And it requires two conditions, one of which has to be present. Either the settlement agreement needs to be incorporated into a final judgment, or the settlement agreement needs to be approved by the order and expressly retained. The order needs to expressly retain jurisdiction to enforce the settlement agreement's terms. Without these two, then an independent action needs to be filed in order to enforce a settlement agreement. In its initial brief, in its answer brief at page 45, I believe the foundation has conceded that the second condition did not exist, that the approval order didn't at least expressly retain jurisdiction. Instead, the foundation is arguing the trial court had inherent jurisdiction because the settlement agreement was incorporated into a final judgment. But respectfully, this is incorrect for two reasons. First, the approval order was not a judgment. It was a final order because Florida Rule of Appellate Procedure 9.170 B25 states that an order approving a settlement in a probate administrative proceeding and relieving the personal representative of liability is a final order that's appealable, but not all final orders are judgments. A judgment typically disposes of the entire whole merits of the cause, which in probate means that the probate's administration has come to a conclusion. Indeed,
Mr. Donovan, that brings up a question I want to ask. Does the fact that this was a probate proceeding constitute a wrinkle that Palucci sort of leaves unaddressed?
I don't know that yes, Palucci doesn't address probate situations.
And are there any cases that have applied Palucci in the probate context? I couldn't find any. I didn't know if I was missing any.
No, Your Honor, I don't believe that any of them have, not in the probate context, but I'm not entirely sure that it's a distinction without a difference because
Actually, Mr. Donovan, and I'm glad Judge Yoakum brought that up because that was my question too. Probate is always ongoing and it's continuous. It's not like any typical litigation or lawsuit where you have a finality. And the fact that the actual settlement was incorporated in the order, doesn't that render itself that the court has continuing jurisdiction because it is in the probate realm?
Respectfully, Your Honor, I'm disagreeing with the premise of your question. I want to answer it, but I don't believe that it was incorporated into the approval order. It mentioned the settlement, but it did not incorporate into the approval order. In fact, the case law generally requires a very explicit, unequivocal statement that it is being incorporated. In fact, the Fernandez versus Fernandez case was a situation, albeit a marital dissolution action, where the final judgment referred to the settlement agreement, but the court said that the mere reference to it isn't an explicit, unequivocal incorporation. And I think that Palucci kind of goes to that as well and would be applicable in the probate context, whereas Your Honor pointed out that there's a lot of final orders that come out of probate before the probate's administration, because Palucci, I believe it was in a footnote, stated that the reason why it needs to be very clear that it's expressly reserving jurisdiction or is incorporating the settlement agreement is so that all parties in the court know that the enforcement is going to be by motion rather than by independent action. So I believe that to answer your question, I don't think that that's a correct reference in this situation because there was no incorporation. The approval order, for example, didn't say it was incorporating the settlement agreement. Didn't say, now I believe the foundation argued in its brief that it was approving and adopting, but it actually didn't say adopting. It just said it was approving. And it didn't say it was subject to. It didn't, as some of the other cases that foundation argued that were probate, they said, I believe it was something like the parties shall all comply with the settlement agreement. It didn't say anything like that. All it did was recognize that the personal representative could enter into the settlement agreement, and it relieved him of personal liability so that other interested persons could not later sue him for entering that. That's all that the approval order does. That's all that the probate court technically could do under 733.708. Therefore, it's not a judgment, nor did it incorporate the settlement agreement. Therefore, even in the probate context, Paolucci has not been satisfied here. And therefore, I believe this court should reverse and remand with instructions to dismiss the motion, because their only avenue for relief to enforce the settlement is by an independent action. Alternatively, the probate court lacked personal jurisdiction over the trust, which was neither served with process nor any of the enforcement documents.
Wasn't the trust part of the settlement, though?
The trust was part of the settlement, yes.
Yeah, I mean, didn't they submit to jurisdiction by signing on to the settlement?
Respectfully, no, Your Honor. They signed a pre-suit settlement that in and of itself was only approved because the personal representative wanted to be relieved of responsibility or obligations.
But your client, who was also the trustee of the trust as well as the PR of the estate, right?
That's correct, Your Honor.
Okay, and he got served as the PR, correct?
As the PR, yes.
Did he get served in his individual capacity as well, or just as PR?
Well, I believe he filed the petition for administration in his individual capacity and then was appointed in his personal representative capacity, but he never made any appearances or never, sorry, Your Honor.
Well, I mean, so in other words, the trust never made any arguments in any of these proceedings? No one ever, took their position? Did anybody raise the issue that, hey, they haven't been served, they're not part of this?
In the motion to enforce, the estate did say that the court can't enter because the enforcement would be against the trust, since that's the only one that had obligations under the settlement agreement. So the estate did raise that the court can't enter this enforcement order because the trust isn't here, because trust hasn't been served. That's the only time that there was any arguments related to the trust, and the trust itself never made any appearance. Nobody appeared on behalf of the trust in these probate proceedings. And I think the fact that this was a probate administration is important to emphasize, because in a probate administration, there's really only one party, and that's the personal representative. And the foundation wants to argue that the jurisdiction existed by virtue of the fact that of the statutory framework, but section 736.0201, 0.0202, and 0.02025 both state that judicial proceedings involving trusts must comply with Chapter 48 service requirements and constitutional due process. This court, they rely on the fact that the trust filed a notice of trust under section 733.707, which basically was an acknowledgement to the world that the trust provides that it will pay for the costs and expenses that the estate cannot absorb, basically, because of the estate's assets. But no case has ever said that simply because a notice of trust or that situation existed for a trust where they would be forced to pay estate expenses and taxes. No case has said that simply by filing that notice, they have now subjected the trust and its assets to the probate court's jurisdiction in its administrative context. In fact, this court's Estate versus Stizzer case basically said that that's not correct, because in that case, the trial court believed it had jurisdiction because the trust said that it must pay estate taxes and fees, and this court held that a trustee must still be served with formal service of process to affect the assets in a trust. Here, the only party who filed anything was the personal representative, and the only party who filed the request for approval was the personal representative. And the only party that's actually benefited from the request for approval was the personal representative who's relieved of liability. The trust did not file anything, so they have not voluntarily subjected themselves to the probate court's jurisdiction, nor has does the statutory framework in and of itself satisfy the condition of personal, the requirements for personal service as required by Chapter 48. And at a minimum, even if the foundation was able to show that there was personal jurisdiction, none of the enforcement, the motion to enforce, the amended motions, the supplemental stuff that was filed by the foundation, the notices of hearing, none of that was actually served on the trustees. And no attorney appeared in these proceedings on behalf of the trustee. Now, I know that the foundation argued, well, at the settlement, the trust was represented by the same attorney that represented the personal representative, or that's reflected under the settlement agreement. But again, that's not appearing in these proceedings. The proceeding was the probate administration, and the extent of the probate administration's jurisdiction was the foundation's claim and the personal representative's objection. And at that point, the onus was on the foundation to file a separate lawsuit against the estate and the trust to enforce the pledges. Therefore, simply because they entered into a pre-suit a pre-suit settlement that at the time the settlement was both parties were represented by the same attorney, does not mean that the trust has said that this attorney is going to represent them in an enforcement action to enforce the settlement agreement. Therefore, at a minimum, that would require reversal because the trust was not given any notice of the enforcement action, at least as required under due process. Therefore, this court should reverse for lack of due process and a lack of service on the trust. Finally, the trial court should not have found that Rule 1.540 barred the estate's fraudulent inducement defense for two reasons. First, Rule 1.540 does not apply to non-adversarial probate proceedings. In fact, that's provided for in Probate Rule 5.010 and 5.025 to make this very clear. And none of the cases that are cited by the foundation address those two rules, which isn't really a surprise because they involve testamentary disputes, which are adversarial automatically under 9.025A. So therefore, Rule 1.540 doesn't apply. And if as the foundation argues that the probate court had inherent jurisdiction to enforce the settlement, then it's a court of equity, and it would have equal equitable power to not enforce the settlement due to fraud. And in fact, the fact that the foundation characterizes 1.540 as a statute of limitations sort of buttresses this argument, because typically limitation periods do not apply to defenses, to affirmative defenses, which is precisely what the estate raised in response to the enforcement motion. Otherwise, as the Supreme Court recognized, albeit in a different context, that it would allow the wrongdoer to purge any fraud-infected settlement by simply waiting to enforce it. And notably, the foundation did not address the specific argument in its answer brief with respects to the fact that statute of limitations periods do not apply to defenses. Alternatively, Rule 1.540 doesn't apply because this was a pre-suit settlement agreement. Thus, it was at best extrinsic fraud, not intrinsic fraud. Typically, extrinsic fraud is conduct that prevents a person from presenting their case. And as the Supreme Court recognized in the Columbus Hotel versus Hotel Management, a fraudulent procurement of a settlement agreement can constitute extrinsic fraud. In fact, the Supreme Court specifically recognized that in affirming the trial court's denial of a motion to dismiss for failure to state a claim, stating that this was characterizing it as extrinsic fraud. Now, I know the Supreme Court went on in Columbus Hotel to actually decide, after a full trial, mind you, that it was unreasonable for the parties in that case to rely on the representations in reaching the settlement because fraud and dishonesty was already in dispute in Columbus Hotel. But that doesn't exist here. Like fraud and dishonesty we don't really know why there was an objection. Could have been a procedural issue for why the estate objected to the foundation's claim, but it wasn't related, at least as far as I know, it wasn't related to fraud and dishonesty. Therefore, the Supreme Court.
15, Mr. Donovan, just so you know, it's your time. Use it as you want.
Thank you, Your Honor. I'll just sum up by saying that both the Supreme Court and Columbus Hotel, as well as this court's DiMaggio versus DiMaggio, both recognize that fraud in the procurement of a settlement constitutes extrinsic fraud. Therefore, at a minimum, this court should reverse or remand for a hearing and discovery on the fraud defenses that the estate raised. Thank you, Your Honors.
Okay, you'll have 4.5 minutes when you return.
Thank you.
Ms. O'Keefe?
Yes, Your Honor. Please the court. I represent the New Common School Foundation, the charitable organization, the New Common School Foundation, which I'll refer to as the foundation in my presentation. I'll also refer to the order approving the settlement agreement as the approval order in the presentation, as in the order enforcing that approval order as the enforcement order. So
you might want to go to the jurisdictional issues first, because they appear to be the most thorny here. And if you can't get past those, then whatever else you have to say probably isn't going to matter that much.
Well, Your Honor, I respectfully disagree, because there are two cases here, Arrieta, decided by the Supreme Court, and Winston. Those two cases apply. And in the situation that we have here that is directly opposite to those two cases. In those two cases, Your Honor, they were both probate matters. In both of those situations, agreements were submitted to the court for approval. In both of those cases, there was an order approving the agreement. In one case, in Arrieta, it was a final judgment. In another case, it was an order approving an agreement between the parties. In both of those cases, there was a challenge to the order more than a year later. And in both of those cases, there was an order by the court that the misrepresentations regarding, or the alleged misrepresentations regarding the agreements, were intrinsic fraud. And as a result of a finding of intrinsic fraud, the court ruled that the findings or the allegations of fraud raised judicata as to those particular orders. That means all of the arguments with respect to subject matter jurisdiction, which is mischaracterized here, and personal jurisdiction, and the argument that 1.540 somehow doesn't apply, are all barred. So we start with that premise. And I'll come back to that because it is important that the court look at this case in that order, rather than looking at the subject matter or the jurisdictional issues, because those jurisdictional issues are barred. But I will go ahead and address the arguments that Mr. Donovan has raised regarding subject matter jurisdiction. First of all, looking to Paolucci, the reliance on Paolucci, the appellant has misrepresented that case. There aren't just two conditions, and I would reiterate that Paolucci, Your Honor, says you're correct that there is no case applying Paolucci in a probate matter. But even if you applied Paolucci here, you clearly fall within this the item or the factor of requiring a final judgment. So,
if I may, Ms. O'Keefe, didn't Paolucci? It did in Paolucci. It did recognize the court's inherent authority to enforce a settlement, but I thought the language there that so long as it incorporates the settlement agreement into either a final order or a judgment.
And yes, Your Honor, it is incorporated into the final judgment. The judgment, the order approving the settlement agreement, specifically provides that the proposed settlement agreement will be in the best interest of the interested persons and the estate. And the agreement.
Is anything in the final order, is the word judgment used anywhere in the final order?
The word judgment is not used in the final order. The word judgment is not used in the Winston case either.
And,
But
and did this final order resolve everything? Was the case done?
This final order did resolve everything. And if you look at 9.170, I think it's 28, it says that an order like this one that is issued with regard to 738, the statute 738 provides that it is a resolution of all of the issues. It's a final order that resolves all of the issues. So they requested a settlement agreement pursuant to 733.08. That statute in it per 9.170 confirms that all of the items that were addressed in the case were final.
Well,
So
the settlement agreement resolved all the issues, right? The only thing that the court's approval resolved was whether somebody could come back and sue the PR. Right? I mean, the settlement agreement didn't have to be approved by the court. That was independently binding, right?
This was a material term of the settlement agreement, a material term of the settlement agreement that it was, the parties submitted it to the court and it was contingent on the court's approval. If the court did not approve it, if the court did not find that it was in the best interest of the parties, the settlement agreement would not have been effective. So it is specifically contingent on that provision in the settlement agreement.
No,
I
I understand that, Ms. O'Keefe, but if I may, but it doesn't answer what Judge Yoakum just asked you. Didn't that order, the whole purpose of that was to relieve the personal representative from any further litigation or any further matters, which is different from an order that says we approve the terms of the settlement and the court will retain jurisdiction in order to make sure that we enforce the contents and the matters therein. Aren't we talking about two different things?
Your Honor, I respectfully disagree. The fact that this order was issued based upon a settlement agreement parties specifically submitted to the court, and they submitted it to the court knowing that the trust was obligated to make these payments and knowing that the court had found that had to find it was in the best interest of the parties. The statute itself, the rule itself, 9.170, confirms that this resolved all of the issues with respect to the parties. So it's a final order and it resolved all of the issues presented. And I want to tie that back to Arrieta and Winston, because in those cases, Your Honor, if you look at it, those cases involved orders that were equivalent to this one. And they recognized that they were final. And in Arrieta and Winston, the parties there were in essentially a non-adversarial position. But they resolved these issues just as the settlement agreement did here. With respect to Arrieta and Winston, I'd also like to point out that those cases involved misrepresentations that were specific to, or misrepresentations that were specifically found. They were related to the settlement agreement as they are in Arrieta versus Winston. Those false allegations that the trust and estate asserted were without doubt time barred because they were intrinsic fraud per Arrieta and Winston. They assisted on raising these issues. So I want to, before I leave the issue of personal jurisdiction, or before I leave the issue of intrinsic versus extrinsic fraud, I do want to go back to the issue of personal jurisdiction. Mr. Donovan has asserted that the order was not incorporated into, or the order was not incorporated. into this final judgment. But we've expressly incorporated the order, and the, as I've said, it's dependent on the court's approval. So with respect to the personal jurisdiction, there is no question that the party had notice, no question at all. The jurisdiction, it was established by the statutory framework. Statutory framework, particularly 737.07 regarding the trust, financially obligated the estate to
All that's true, but I personally, in all my years of doing this, have never heard that someone is in an action when they haven't been served. I mean, that's a new experience for me. In order to be brought into an action, you need to be served.
Your
Or
Honor,
otherwise, submit to the jurisdiction.
Your Honor, they submitted to the jurisdiction of the court in multiple ways. The first was they filed the notice of trust. So the assets there.
Well, who would be the they that filed
Sorry.
that note?
The attorney for the trust, who is also the attorney for the estate, filed that notice of trust.
As attorney for the trust?
As I recall, they filed that as,
Well, I mean, that's, if it's the same attorney representing both entities, unless they actually, file and represent they're doing it on behalf of the trust, then I don't know how that pulls them in. So that's a critical fact.
so the trust and the estate are represented by the same attorney. And in fact, in this case, that attorney specifically asked for relief for the trust. In its filings, it specifically said that in its wherefore clause, specifically said the probate court, or asked the probate court to invalidate the settlement agreement with respect to any obligations of the estate and the trust. In the hearing on these issues, the court, the estate asked that mediation be ordered for the benefit of the estate and the trust. There's no issue with respect to the notice. Certainly the court had, or the trust had notice for multiple reasons. One, the attorney was on notice, and the attorney was representing both
Well,
parties.
notice is one
to
thing,
the statutes.
but being served or submitting to the jurisdiction is another. So notice is not persuasive to me, but I'm listening carefully to what you've said about how the trust submitted to the jurisdiction by participating in the action. Are there any other points other than the ones you've raised?
Yes, Your Honor. We have raised the statutory framework that expressly provides that this is a situation where the trust has submitted to the jurisdiction of the court pursuant to section 733.7073, which explains that a trust in this situation must pay for the expenses, the obligations of the.
Well, I get that. I get that. I'm aware of that. The trust is holding all the money, basically. But that doesn't mean that they've submitted to the jurisdiction just by virtue of the fact they're holding the money.
Well, they also submitted to the jurisdiction with respect to the settlement agreement. It wasn't just the notice. Together with the settlement agreement that specifically said, we are going to make this payment, they submitted to the court that they were going to do that. So they submitted to the jurisdiction.
First of all,
So
They
the settlement agreement
they
was
didn't
signed
send-
off on behalf of the trust?
The settlement agreement was expressly signed by the trust. Both the
Okay.
trust and the estate required court approval. They required the court to act on the settlement agreement before it could be approved. The court had to find it was in the best interest of all of the parties, including the trust. And not only that, Your Honor, the trust voluntarily submitted to the court's jurisdiction in entering the settlement agreement, which definitively benefited them in several ways. One, they didn't have to defend an independent action. This settlement agreement resolved the independent action that could have been.
Yeah, but all that happened before the action we're talking about. This is a motion to enforce, right? This is an action to enforce. And the question is whether or not the trust was part of that action.
Well, there's two issues. There's the personal jurisdiction issue, and there's the notice of enforcement, or the notice of the enforcement action. And with respect to the personal jurisdiction, you look to the notice of trust, you look to the settlement agreement that they submitted to the court, and you look to the fact that they voluntarily submitted to the court with respect to the obtaining the benefits, the specific benefits of that agreement.
If I may, Ms. O'Keefe, I'll tell you what's troubling me and help me out. Let's just say, and I'll use myself as an example. I resolve a case, I enter into settlement agreement in a matter, okay? Then does that mean if there's any issue with what I have done, then I am fair game to be pulled in without being served that there's an issue with my whatever settlement that I've entered into? That's what I'm troubled with, because you keep saying that the trust already entered into this agreement. Well, that's all well and good, but we're talking about the next step to put the trust on notice in order to have due process, that they in fact would be served. I'm troubled by that, because I still am concerned with the line of cases that you're relying on, that typically when courts to enforce its own orders, to enforce the settlement, those somehow have to be incorporated in the final judgment itself, the final order, in order to maintain, jurisdiction. So help me out. By virtue of me entering the settlement agreement, I'm fair game to be pulled in?
In this particular situation, yes, because the estate, the trust has stepped into the shoes of the estate, essentially, to take on its obligations. Pursuant to the statutory framework, the estate and the trust is required to make those payments. So notice to the trust, jurisdiction over the trust, all of that is settled by notice and jurisdiction of the estate. The estate and the trust both are obligated to make the payment of the original pledges. The estate or the trust could have been sued with respect to those if they failed to, or if the appellant continued to have the objection. But what happened is the estate and the trust, they both together were obligated pursuant to 737.07 to pay for those. So there is no distinction for purposes of this case. If they wanted, if my client, the foundation, wanted to pursue the estate, the trust separately, it could have done so. It didn't need to. It didn't need to. So that resolves the personal jurisdiction issue. You've got jurisdiction over the estate, and that's all that you need. With respect to subject matter jurisdiction, again, Pellucci they've misconstrued Pellucci. What the appellant has done, what the trust and estate have done, is misconstrued a number of cases in order to avoid paying a settlement agreement, in order to avoid doing what was desired by the deceased in this case, right?
Okay, well, Ms. O'Keefe, help me out with that, because maybe I'm misconstruing it the same way then. So I'd like you to very clearly explain why Pellucci is being misconstrued in this context, because it seems pretty clear to me what it says.
Pellucci is being misconstrued in this context because it says, first of all, that the issue that has been raised is continuing jurisdiction, not subject matter jurisdiction. It relies on MCR funding for that proposition, and it relies on Buckley for that as well.
Okay, that's fine. That's fine as far as it goes, and I understand that point, and I understand that case law in our district and throughout the state hasn't done a very good job of distinguishing between continuing jurisdiction and subject matter jurisdiction. And it's all sort of lumped together. But to the extent that it has been lumped together, our precedent is pretty clear that regardless of what you call it, continuing jurisdiction also is not waived. And so I don't think, frankly, in this context, it's really been teed up for us to make any sort of real distinction between continuing jurisdiction and subject matter jurisdiction. So maybe that's a valid distinction, but why does that matter here when it seems like regardless of what we call it, you can't waive it?
Well, you can waive it, and the reason being is this. With regard to Palucci, that case provided for two different instances in which the court agreed that a court would continue to be able to enforce its order. One was a final judgment, adopting the settlement agreement, which is where we are. The other was the situation where there's a voluntary dismissal, there's no adoption of the settlement agreement, and there is no subsequent order of the court specifically reserving jurisdiction.
Ms.
Now, all
O'Keefe,
of the
you're out of
cases-
time, so please wrap up.
Certainly. So all of the cases in the Second District Court of Appeal that have been cited by Mr. Donovan address a situation in where there was a voluntary dismissal, there was no settlement agreement, and as a result, there was no jurisdiction in those cases. Whether you called it subject matter jurisdiction or whether you called it continuing jurisdiction didn't matter in any of those cases. But what's happened here is Palucci has specifically said it's continuing jurisdiction, and it relies on NCR funding for that proposition. And NCR funding
Ms. Keefe, you're way out
specifically
of
says
time,
that in
so
cases
please
like
wrap
this
up.
one, I'm sorry, Your Honor, and yes, so I hope that answers your question, Your Honor. Thank you very much for your time.
Okay, thank you. Mr. Donovan, I'm going to give you your full 5.
Okay,
because
thank
she
you.
Bled
I mean,
well
hopefully
into
we'll
her
need all
time,
that.
okay?
But, I have two main points. The first one is, while we were sitting here, I reread Arrieta and Winston. I don't see where they incorporated a settlement agreement into a judgment. The closest reference to that I can find is in Arrieta, where it says, excuse me, that the settlement was then reduced to a consent judgment, and that simply didn't happen here. And at best, both of those cases are before Palucci, which created a much more bright line rule. The second point is that the trust has never made an appearance into this case or agreed to be subject to the personal jurisdiction of the probate court. It did file a notice of trust, and the only reference on there to the people were the actual trustees. There is no reference to an attorney on this document. So I don't know whether or not an attorney filed it. It's possible. I know that she opposing counsel identified how the timestamps were similar, but it certainly wasn't an attorney saying, I'm representing the trustees in this probate matter. At best, it was helping them file something through the portal. And the estate's motion also, the estate's motion for responses and requests for relief, it simply was arguing that the trust has been served. I mean, it wasn't representing that it was filed only on behalf of the personal representative. It wasn't representing that it wasn't stating that it was representing the trust. And finally, the simply participating in a pre-suit settlement agreement, as Judge Kuzam essentially recognized, that simply participating in a pre-suit settlement agreement is not the same thing as agreeing to be subject to a court for a probate court for its enforcement. And in fact, nothing in the settlement agreement states that or provides any enforcement mechanism, doesn't state anything what's happening in default. It only says that the personal representative can seek approval. It doesn't even say that it can seek approval and reservation of jurisdiction to enforce or incorporation, which the expression of one thing is the exclusion of another, to suggest that that wasn't the party's intent. That rather the party's intent was to require any enforcement to be by separate action and independent action that provided personal jurisdiction to all the individuals who were allegedly not complying with the settlement. Therefore, this court should respectively reverse and remand with instructions to either outright dismiss the motion to enforce and require an independent action, or if it's on the third ground, to require discovery and an evidentiary hearing as to the enforcement. Thank you, Your Honor.
Thank you both very much. Your briefs were excellent. Your arguments were also, and they will help us very much in trying to solve this issue. Okay, have a good day.